Right.
Take your seats. We're going to go ahead and get started. Thank you all for joining us for this public hearing tonight. This is a public hearing for proposed groundwater discharge permit for Generate Fremont. I'm going to go through a couple things before we get started here, though. My name is Ryan Blazek. I'm with Eagles Environmental Support Division. I'll be moderating the public hearing tonight. I'm also the hearings officer. This is what our agenda is going to look at like for those of you who can see it here. We're going to go through an introduction. So we're going to go through our Eagle staff who are here today, and we're kind of going through that right now. We'll go through a presentation by Eagle staff about the permitting process, functions, and the proposed permit. Well, the Q&A session, we'll be able to ask questions of our Eagle panel who will be up here related to the application. And then we're going to go to the official hearing portion. That's where you'll have a chance to make a statement for the record on this application. And you'll have, when you came in, you may have seen there were little hearing cards. We'll use those to start off making your statement. So Yvonne's in the back of the room. So at some point, she'll be passing out additional hearing cards if you haven't received one, and we'll go through those to make your statements. Then we'll go through the wrap up. And to wrap up, we're going to go through the other ways to make a comment, who to contact with further questions. And we'll be wrapping up at around 8:10 tonight. All right, so with that, we're going to go ahead and go through our Eagle staff so you can put a name with the face here. I'm just going to go down. I'm Ryan Blazek, as I mentioned, the hearings officer with Eagles Environmental Support Division. We have Christine Alexander with permit section, who's the manager of permit section with Water Resources Division. Christine Rendon, who is the groundwater permits supervisor for Water Resources Division. Alyssa Yanachko, who's groundwater permit section, Water Resources Division, an engineer, also permit writer for this permit. Angela Strong, the groundwater permits unit, a geologist with Water Resources Division. Vincent Josic, who's a groundwater permits unit, who's a soil scientist. Amanda St. Moore, who is a compliance staff with Water Resources Division with the Grand Rapids District Office. We have Fred Sellers, who is the district supervisor with Materials Management Division out of the Grand Rapids District Office. And we have Abhi Mudugandhi. Abhi is the Sustainable Materials Management Unit engineer of Materials Management Division. One other thing I wanted to mention is just so you're aware, the hearing is being broadcast tonight online for those who wish to participate virtually. So for those of you online, welcome. However, we won't be taking questions or comments directly from the virtual audience tonight, but we will be providing them with the other ways to make a comment and provide them the information for asking their questions. The hearing is also being recorded. It'll be on Eagle's YouTube channel a few days after the hearing tonight. All right, with that, we're going to go ahead and kick off the presentation. So I'd like to invite Alyssa to go ahead and start the presentation.
Thank you. Again, my name is Alyssa Yanachko. I work in the groundwater permits unit as an engineer, and I also do permit coordination. So in this case, I was the permit coordinator who works with the technical staff in our groundwater discharge permit to create a draft permit. So when I do these presentations, I like to start off a little bit about how we fit into Eagle. And, there's over 1,000 staff within Eagle. And so we're really just one portion of the whole department. Eagle's job is to protect Michigan's environment and public health by managing air, water, land, and energy resources. And so WRD implements the programs that all work to protect the waters of the state. So within Eagle, we're in Water Resources Division. Water Resources ensures Michigan's waters are safe and clean for things like drinking, recreation, fishing, and just a general healthy aquatic ecosystem. We administer programs from anywhere from our groundwater discharge permits program to other water resources programs like wetlands. Within the division, we're in permit section. Permit section issues all wastewater discharge permits in the state. So that includes surface water permits, or you might know it as the National Pollutant Discharge Elimination System, or NPDES, or the groundwater discharge program which is just known as the Groundwater Discharge Program, but we in particular operate only under state law, so there's no federal program for our groundwater discharge program. It's only the state. And then within the section, we're in Groundwater Permits Unit, which issues all the groundwater discharge permits for the state. So I also like to go over a little bit about why our permits are so important. When the Groundwater Permits Unit issues permits, we look at protecting all waters of the state. So that includes surface water. Whatever goes into the groundwater can and will vent to surface water. So all the waters are connected. So we're looking also at surface water protections for things like recreation and wildlife and healthy ecosystems. And we look at groundwater for drinking water protection. The groundwater is used for a lot of drinking water in Michigan. There's over 2.6 million Michiganders that use drinking water. So their sole source, or I'm sorry, groundwater is their sole source of drinking water. And that equates to over 1 million private drinking water wells. So you heard me mention, this is a state-run program. So in particular, we operate under the Natural Resources and Environmental Protection Act, or NREPRA. In particular, we operate under Part 31, Water Resources Protection. And then promulgated pursuant to Part 31, there's a variety of other rules. You'll often hear us bring up the Part 22 rules, which is specifically for groundwater quality. But we also touch other rules throughout our regulations, including things like Part 21. The Part 21 rules, which cover general administrative actions for us, as well as things like the Part 4 water quality standards. And so generally, when we're looking at a groundwater discharge permit, there's a couple different components. The permit is required for any sort of discharge to the ground in the state of Michigan. So whether that be a wastewater treatment plant, a food processor, or in this case, the digester, a permit would be required for any of those discharges if they are to the ground. Groundwater permits are written to be protective of, again, both groundwater and surface water quality through the means of effluent limitations, monitoring requirements, or any other conditions that we might deem necessary to control the discharge of pollutants. And then permits are enforced throughout submitted reporting and regular compliance inspections throughout the state. And then overview of the general permit process. So when we issue a permit, it's effective for a maximum of 5 years. So every time a permit comes up for reissuance, we reevaluate it through similar means to the original issuance, with the addition of things like their effluent sampling through digital monitoring reports. We look at their flows and wastewater characterization, and then continue to look at other things that may have accrued throughout the permit cycle, such as violations or compliance inspections. And then we also redo, our technical staff will complete reviews again for the facility. So moving on to the application we're here to speak about, the digester, or Fremont digesters and anaerobic digesters that accept a variety of things such as food waste, food byproducts, or wastewater treatment system residuals. Those items are broken down to create biogas that can be used to create electricity. But during this process, byproduct called digestate, in this case, you'll sometimes hear supernate as another common name. It's essentially the leftover material that cannot be used during that digestion process. So in the case of Generate Fremont, that digestate is stored in 2 lagoons and then is land applied to multiple fields throughout Oceana, Muskegon, and Nuevo counties. And they apply anywhere from 1 to 3 applications per year, depending on the type of crop. If it's corn, they may apply only once. If it's hay, they may apply up to 3 times. So once we review an application, it goes through a variety of technical reviews. The first one that I'm going to talk about is our soil scientist review. So they look at primarily 2 items. The first of those being nutrient loading and crop uptake. So they're looking at things like how much nitrogen can the crop uptake, how much phosphorus, and what the potential loading is for that. And then the second factor is hydraulic loading. So we're looking at the types of soils, how much water can they actually take to make sure it doesn't create ponding or pooling. And then during their review, they set standards for the permit, including things like the method of application, the timing, the volume, or any other restriction they feel is necessary to protect groundwater quality. So in particular, if you have a copy of the draft permit in front of you, you can look at part 8.2, and that kind of lays out some of the land application restrictions that our soil scientists recommended. Second is our geologist review. So again, they did a couple different things here. They did review the monitoring well data that was available for the wells around the existing lagoons. And then they also took a look at each individual field that's currently proposed to be applied to. So they look at the general geology of the area using a variety of factors, one of the biggest of those being nearby drinking water well logs, to help look at the general geology of the area. And that includes things like looking if there are confined aquifers, unconfined aquifers, if it's clay or sand, as well as other things like what is the number of drinking water wells in the area? Is it in a wellhead production area or potentially known areas of high entry? So once those two reviews are completed, we bring those together and create a draft permit that we believe is protective of groundwater quality. So I have just a general walkthrough of the draft permit up here. We're gonna go through most of these, but in terms, or for Generate Fremont, we have effluent sampling requirements. We have effluent limitations in the form of the allowable discharge concentrations. We have land application requirements, schedules of compliance, and requirements of when monitoring wells are required. And we'll go through each of these a little bit individually here. So again, the effluent sampling we require is on, I believe it's the third page of the permit. So it includes our non-metals, which are kind of the standards for our unit, a full list of metals, and then the volatile organic compounds that were detected in the digestate previously. So for the VOCs, we're required to sample for what is known to be in the discharge or what may be in the discharge, and that's why those VOCs are in there. The sampling, so then these parameters are used to determine compliance with those allowable discharge concentrations that are in the appendix of the permit. The land application restrictions, which we talked about, came from the soil scientist review that we felt were necessary to be protective of groundwater quality. In particular, we required that the digestate be surface applied to maximize the potential for that uptake from those crops. So surface application or surface and then incorporation, there's no injection allowed under the draft permit. The application rates are restricted to 1 inch per day. They're not allowed to apply during significant rain or snow events, as well as it's restricted to a specific growing season. And then there were a couple of things that we wanted to require for land application that the facility is not currently meeting. That's just the difference of it being an existing facility. When we find existing facilities that might not meet all of our requirements upon permit issuance, we're required to give them time to be able to come into compliance with those requirements. So some of those examples are they cannot land apply to tile fields. The crop must be growing. Fertilizer application, sometimes there's some pre or post application based on our requirements. We don't want that occurring, and so they're going to have to change their operations to come to compliance with that, as well as a more restricted growing season. And another one, which isn't under the title of schedule of compliance, is the pollutant minimization program, which there are some parameters within that allowable discharge concentration that they cannot currently meet based on our requirements. And so we are giving them time to identify potential feedstocks or potential processes that are occurring at the digester that may result in those pollutants being present. And then monitoring well installation. So there is a section specifying when monitoring wells may be required for a field that is linked to the geologist review and evaluation of what would be considered a high-risk field. So those are fields that do not meet our minimum requirements to protect potential receptors. So in this case, something like if they're discharging in a wellhead protection area, they don't meet the minimum isolation distances to drinking water wells, or that it could be a very sandy field with a large number of drinking water wells in the area. We see those as a higher risk, and so we want to make sure that we're protecting that drinking water source. And then the last thing here is the existing monitoring wells. We did require continued monitoring of those wells around the lagoon. Currently, it's a twice annual sample, and it's just to ensure the protection of groundwater quality around those lagoons. The findings here, we went through a brief overview of the draft permit, and I wanted to talk a little bit about next steps after this public hearing, so everyone's aware. We'll continue to collect comments after our verbal comments, though we'll continue to collect them through My Enviro to November 27th, 2024. It ends at midnight. Once we collect all those comments, we'll look through them and we'll review them and create a response to these comments in a document, which we refer to as a responsiveness summary. Some of the same comments will be grouped together, so we want to repeat ourselves. And then everyone who commented or and provided contact info, so commented, or if you signed up, you don't want to make a comment if you signed up through our sign up sheet, you'll also be notified. You'll receive that document as well as with the department's final determination on the permit. So the final determination could be the denial of a permit, the issuance of a permit, or the issuance of a permit with changes made, and that document will highlight, if it's issued with changes, what those changes are. And then we're going to highlight this a couple times throughout this, but just so we have it, I wanted to go over really quickly about how to find the site in My Enviro. So here you can see there's the page. This should be the opening page for My Enviro. You can select the public notice search, and then you'll open up to this page. There's a couple different ways you can search. I find the easiest to just type in the name under the site. So in this case, I just typed in the word generate and it came up. You would then select view/submit comments. And there's a couple different tabs here. There's the document tab, which does have quite a few documents in it that were all either connected to the draft permit or with the application. But if you want to add a comment, you'd select on that tab, add comment, and then this would come up for you to fill in the required information and submit your comment. You can also attach Word documents or PDFs. If you guys have any issues finding any documents, my contact information is in here, as well as I'm happy to provide it. I can always send individual copies of like the soil reviews or the draft permit if you have trouble finding that. I know there's quite a few documents in there, so that's it for my presentation. I think we're going to move on to the Q&A session after this. I found my contact information. So my contact information is up here. I think that's it. We can move on to the Q&A.
Thanks, Alyssa. Yeah, so I'd like to invite the panel to come up. So what I'll do is I'll run the mic around here. To anyone that has a question, you just raise your hand and I'll try to catch you. If you can ask a question of your panel, just a reminder to speak up so our online audience can hear you. Mic seems to be working pretty well.
Hello. So the permit calls for applications not to occur when there's a half-inch of rain forecast. Tomorrow, there's 1 to 2 inches of snow forecast, and they're spreading. So what is the process for monitoring to make sure that improper spreading isn't occurring?
Question. Is that working?
Yeah.
Yes.
Okay. I can talk generally. So currently that requirement is in the draft permit. The draft permit is issued. So they're currently not held the requirements in the draft permit. I'll pass it over to Fred and he can talk about what their current requirements are.
Is that better?
Yeah, under their AUA. I think you had what was the last question you had?
I wanted to know how you monitor.
How we
when
monitor.
they're, I mean, are we leaving it up to the digestate owner to monitor themselves whether they should be spreading or not?
So groundwater discharge permits are self-monitoring with frequent compliance inspections. So when our compliance staff go out to do an inspection, they'll check their records and things like that to ensure that they're keeping records and they're maintaining what they're supposed to be doing. If someone has a concern, they can always report it to our Keys line or to our compliance person. But generally, permits are self-monitoring. Fred, I don't know if you want to talk about the AUA.
So currently under the AUA, the way it's written is part, I think it's J, L. And basically it just says, company shall ensure that the material is not applied in a manner that adversely restricts soil permeability or causes ponding, pooling, or runoff in the area. And it has requirements for slope limits. So that's basically it. So it can be raining so long as it's not pooling and ponding. And as far as the monitoring that is done on that, we would just, if we have a complaint, we come up and check it out. In addition, I encourage the digester to take pictures before they apply and after application.
Other questions?
In the slides that you said that there were gonna be no more than 3 applications, per year, but then, you kind of skipped over when it said, something about if there were more than 3 applications per year in a different slide. I just wondered if they, and also in Appendix A in the permit, it says, you know, it shows 5 applications per year.
Yeah, so the one slide I highlighted with the 1 to 3 is what's currently proposed in their application. They informed us what if someday we did want to apply more, and so we drafted the groundwater discharge permit in for that situation. With the 3 applications, if they do want to apply to a field more than 3 times, that would require the installation of groundwater monitoring wells at that field. So that's another factor we looked into. The more frequent they're discharging there, the higher we consider it a higher risk field.
I was told by Tim Unseld, seeing as how the field adjacent to our house, only 33 feet away from our well, that they were not to apply more than twice if they were just cutting anything other than corn. And I wish I'd have brought that. He put it in writing for me. So my question is, when was that changed to 3 times?
So again, what I'm highlighting is under their draft permit, proposed draft permit. So the document with the permit, that's not issued yet. So they do not yet have to abide by those requirements. That's what under the Water Resources Program, or sorry, Water Resources Division, we're proposing that they would be required to do. So again, I'm going to pass it off to Fred because I'm not personally familiar with their AUA of, what their requirements under their current AUA are.
Yeah, and again, their applying and they're not supposed to be causing pooling ponding, so the limitations that they had, limitations that Tim spoke to you about were basically for an alfalfa field where they had a fresh cutting and they went out there and basically the soils were saturated after 2 applications, so that meant they weren't supposed to apply beyond that. So that was the current system that they're operating under versus the proposed permit, which is what Alyssa and we're talking about tonight. So it is different from what currently was being done under the AUA.
Okay, thank you.
I just want everybody in this room to know that you're looking at the people who are responsible for issuing Ice Mountain water permit. The company that sucks down our water in Michigan so bad that,
Looking at the statement.
well, I'm just getting in, let the room know, everybody, that these are the people who issued Ice Mountain a permit to take water.
Thanks. And just to clarify, this is question and answer period, and you can say anything and make your statement for the record during the hearing part, but we're gonna try to keep it to questions to get through as many of these questions as we can.
Thanks. Does Eagle plan to conduct any testing before they make its final determination? And when does Eagle expect to make its final determination?
So, the final determination of the permit will be based on how fast we can get through, the public comment. So we know the holidays are coming up here, people take time off, it will take us a while to compile those, comments and, create a responsiveness summary for that. Chris, do you have a timeline for that? It's gonna take as long as it does for us to get through all the comments.
Can you ask the clarification on testing what?
Yeah, can we get clarification? What kinds of testing are you referring to?
Well, on the timeline, any ballpark would be appreciated. But in terms of testing, is there any testing, hydrogeological, PFAS, other testing?
So we do test the digestate itself. They sample that twice a year. And they also sample monitoring wells that are around the lagoons. And since they're trying to close the lagoons right now, the lagoon levels have been drawn way down. And so they're trying to, they're going to be sampling more frequently than that to make sure that they get any kind of changes in the characterization of the materials in there. The digester is no longer generating digestate because they're not operational. So this is just emptying the material that's in the lagoons. And they sample for a laundry list of chemicals that they talked about earlier. And it does include PFAS. They've only taken one sample. We split with them on that sample. And our samples were not exactly the same because they ran different tests than we did, but they are consistent. We are sampling again Friday. My geologist Kent is going out to the site, out to the lagoons to collect samples for PFAS again. And he's splitting with the facility.
Good.
Questions? I'm really empty in the lagoons. I don't see anything going on at ponds.
I'm sorry, what?
They've been emptying them all summer. How do they empty them? Where are they going with the water? I don't see any tractors or nothing.
They're applying it to fields where they can.
That's not emptying ponds. All summer.
So during the summer months, when, if they're applying to fields that have corn in it, they can't apply to the fields that have corn in them. So during the growing season, they're not applying. They'll apply to fields where they have alfalfa, but not fields. So the application is a lot slower in the summer months. So typically more applications being done in the spring prior to planting the crops, and in the fall after the crops are taken out of the fields.
I see a direct dump in 2 streams. What's the problem?
Related to ponds?
we had a complaint, about, potential discharge to the creek. That person's not here tonight, but what I remember from the emails that I read, he did not find any correlation from anything going from the lagoons to any streams. I think Kurt Heisinger, who's in Water Resources Division.
On the screen earlier, it said something about no tiled fields. How can you know for sure that the fields that are getting the application aren't tiled? How can you, are you relying on the people that rent the ground, the people that own the ground, or how do you, because obviously in many cases, the tiles are not. And so many fields are tiled today because they need to be, so I didn't quite get that no tile field.
So I guess I'll first start by saying, the reason that we do not want them discharging to tile fields is because those tiles obviously go to a surface water body, which would then be a direct discharge to surface water. Our groundwater discharge permit does not authorize the discharge to surface water. That would be under an NPDES permit. And in terms of what we're relying on, to some degree, we are relying on them to report if those fields are tiled. I would say, through my time in our unit, that from an aerial, obviously we've asked more questions if we can see a nearby surface water to make sure those aren't tiled. And often from like a Google Earth aerial, you can tell that those fields are tiled. But we do rely on them to submit information that they know to be accurate, and that is a violation if they're submitting, maybe they know it's tiled, they've told us it's not, that is a violation of our rules.
Can I make a request that you stop using pronouns and start using who you're talking about? Because I don't know if you're talking about the landowner, the land renter, Eagle, the geologist. When you use them or they, it's impossible to know who you're talking about.
Okay, yeah, thank you.
Okay, you said that it can't be a tiled field. Is that on a pre-existing? Is that their permit now? Or is that something, because I know of 3 fields that are tiled that have been flooded right around my farm.
So that's not a current, and again, I'll pass off to Fred and talk about what the requirements of the AUA are, but for the proposed permit, it is included in the schedule, because I think our understanding, WRB's understanding was that's not currently a requirement under their AUA, so we needed to provide them time to be able to change their operations to phase out those tile fields. So it is under a schedule, under our permit, which would be I can't remember how many years, might have been like a 3-year timeline for them to discontinue the use of those fields. Fred, I don't know if you want to talk about the AUA.
I don't recall off the top of my head whether the AUA specifically addresses tile fields. I'm gonna continue looking through. I thought that they were not supposed to, but I don't recall that specific restriction in the AUA, but I'll look through it and I'll clarify that.
I was wondering, when reviewing the well logs and the number of wells and as well as the geology of the soils located in all the fields, did Eagle staff go out to these locations in person or only use resources online to collect this data? My major concern with this is that many of the wells in the area are not recorded on WellLogic, mine being one of those, and I'm surrounded by fields. So I'm concerned about the number of wells that are recorded as being impacted, not being accurate and correct. And I do have a second question after.
No, I did not go out and visit the fields in person. I used online resources to do my evaluation.
And then
I can add that generally when we do look at WellLogic or other online sources to determine drinking water wells, if there are wells in the area, or I'm sorry, houses in the area that are not identified as having drinking water wells, but, you know, every other house down the street is, we can identify that, you know, that house probably does have a well, and they do need to meet, say, isolation distances to that, general house, because it's unlikely that those houses aren't gonna, you know, are not gonna have community water supply.
Yeah, I appreciate that. Just didn't know if that was considered during the permit. As well, I know Alyssa, you mentioned that there's frequent monitoring being checked in by Eagle after the issuance of a permit. I was wondering if you could define frequent for us. How many times a year or quarterly, whatever it may be.
Sorry, for clarification, is it how often are they monitoring, or how often are compliance inspections?
Your client, how often are your client, compliance inspections?
Amanda, I'm gonna pass that one off to you.
I'll run over.
Okay.
The division, the Water Resources Division does have a standard for the number of inspections that would be performed, and it's according to the facility and permit type. This one would generally fall under 2 comprehensive evaluation inspections every 5 years. With that being said, we get monthly reports from the permitted facilities that can be looked at any time. We also do just kind of pop in reconnaissance inspections at times and follow up on any complaints that we get.
And then just to clarify, that's the minimum number.
Correct.
Other questions?
Thank you for having the guts to be up there. Please define what 1 inch disposal means. And the permit says 1 inch per application event. Application event is defined as land application location. The land application location that has received digest date 24-hour period. What does 1 inch mean? More importantly, let's pretend this draft permit is issued, including that language. Can you please explain how that's going to be enforced? When an inspector goes out on their scheduled inspection or looking at the documents, how are you going to enforce, what does it even mean, 1 inch per application event? Which, as you said up there in the slide, means basically they can discharge 1 inch per day. Not limited on gallons per acre, gallons per day, it's 1 inch per day. Please define how that's going to be enforced.
Vince, I'm gonna pass on to you to define 1 inch per day. And if you want, I can take on the how we enforce that, but. No.
Yeah, sure. To the inch per whatever, this has certainly been a topic of discussion between WRD and the Generate party, let's say. Our concern with it defining 1 inch per acre, obviously, a lot of people in this room, I'm going to assume, know what we mean by 1 inch per acre. However, the issues sometimes come in when we might be faced by the permitted party saying, oh, I can't even apply to an acre for the state. You know, we got off the field, maybe the field's too swamped, we didn't realize it, so we can only do a half an acre. Party, the sprayer, the applicator might have already calibrated their equipment to put out 1 inch over the acre. And they might say, well, we were calibrated to that, we only got half an acre, or half an inch, but we're not gonna haul all the liquid back, so we just dumped over that half inch. So we were saying 1 inch over whatever area you were able to get to. 1 acre, 1 inch volume, half an acre, 1 inch, 20 acres, 1 inch. Think about address the inch, it's 1 inch over whatever area. And as far as the check on that, you should be filling out logs, how much volume they apply to whatever field. So let's say it's a 23.7 acre field. You take the 1 inch, you calculate it out to the spreadable acreage. It's, in my opinion, because I do it all day, it's a simple equation, figure out the gallons. You check their spreading logs, does it add up? Yes, they comply. If not, it's a violation. I think that addresses both those questions as far as what's an inch and the boundary. Which there's no, I think we're gonna answer those.
No, I was gonna, mention the laws and, the we're good with that,
I
so,
can speak up a little bit.
sorry.
I had some over here.
Hi. Folks, I usually don't hold it close enough. I have a comment and a question, the comment is, I'm picking up and I share the sentiment that this permit, draft permit, proposed draft permit is heavily reliant on the honor system. And I've had discussions with Eagle before regarding other things. Hi, Christine. And I learned that an assumption is, made that the permittee, will follow the rules. I'm not sure that people are very, reassured about that, given the history of the Fremont Regional Digester. So that's my comment. And then my question is, Fremont or Generate Upcycle, when they acquired the facility, introduced depackaged industrial food waste. Not to add to the concerns of the people in this room, but there's mounting evidence that microplastics and nanoplastics, PFAS is a concern, that microplastics and nanoplastics are a concern, and these are not something we want in our soil, getting into our food and farm system. In fact, the University of Vermont did a study and just, a review, and microplastics are ubiquitous in depackaged food waste. And they were so concerned that they actually issued a moratorium legislation. They enacted legislation that issued a moratorium on certifying new depackaging facilities. So you could address the microplastics and nanoplastics concern. Thank you. So I guess what I can say about that is currently Michigan does not have any regulations on microplastics. Our emerging pollutants section, which is Housing and Water Resources Division, did just hire someone to look into microplastics. But currently, in terms of like a groundwater discharge permit, there are no requirements. Chris, I don't know if you have anything to add on that.
All right, thanks.
Brian, I'd like to address the question about the tile field, so if I could go back to that. So looking through the AUA, we don't expressly say that they can't apply to tile fields. What we do have in the AUA is a requirement for depth to groundwater to be at least 30 inches below the surface of the soil at the time of application, realizing that groundwater depth can fluctuate. And then it also prohibits direct discharges. So a tile field would be basically a direct discharge. And if the tiles are below, are less than 30 inches from the soil. And I know when they were applying to some fields, I'm bad with the time, but we had some questions about that 30 inches, meeting with 30 inches of isolation between the groundwater level. And we took some samples, and I'm pretty sure that we sampled a drain that was in the area. I don't remember the field, but I'm going to check with my geologist Kent that was out there collecting those samples, and I'll see if I can make sure we get that to the response in the summary. And if you give me your name afterwards, I'll happily give it to you directly.
Thanks, Rob. All right, also just a reminder, if you have comments, please save those for the hearing part so that we can capture those comments for the record officially. Thank you.
Hi, Alyssa. Thank you for putting up with all of us. I caught in your presentation that there are some parameters that they're currently not meeting for the proposed permit. May you learn what those parameters are?
I'm sure I can go back to the slide.
We can. What slide do you want?
Can I go?
Yeah.
You know what is, I put that in here. So in particular, under the Part 22 rules, there are a couple parameters that are very specific about what the requirement is for those limitations. So in particular, I believe it's total aluminum, total iron, total manganese, and then sodium chloride. I think I got it though. So in particular, because those are as a hard standard in our rule, those are consistently required no matter how many applications they make, whether it be one, whether they be five. And I believe in particular, those are the parameters that they will have issues meeting currently.
I'd like to add sulfate to that as well.
Sulfate as well. And I can take a look for you. I don't know, I don't have the data in front of me. I do remember those in particular, but I can always give you a full list once I can take a look at that data again.
So given that they're in violation, given that they aren't operational anymore and are planning on selling the thing, why on earth are you issuing a new permit? Why not wait for the new owner and find out what their plan is and what their qualifications are and how honest they are?
So we issue our groundwater discharge permit based on the application submitted. Currently, Generate Fremont has not asked us to put the application on hold or halt any of the permitting process. So that currently is the only thing that would stop the process.
Are we allowed to ask that you put it on hold since we're all affected? They're not because they're leaving?
So no, I believe, you know, the public can make comments, but in terms of processing the application, it would be up to the permittee, in this case, Generate Fremont, to make that request.
Does Eagle usually accept applications that are as incomplete as Generate submitted? They had answers like, I don't know. They didn't list groundwater operator. I'm a former teacher and I taught adult students how to fill out applications. And I would have sent them back to square one if they had submitted an application like that. I'm concerned, is this standard procedure for Eagle to accept an application that was that poorly filled out?
So I think maybe some of those things you highlighted, such as the I don't knows, those are fill-ins on the application for questions such as, you know, are you a quarter mile within a Part 201 site? Because if a facility does not have that information, we will check it operators. We'll use our resources to look into that. So in that specific case, that is an option that they can select. Certified operators, new facilities often do not have a certified operator at the time of permit application because those exams are run by the state. I believe they happen twice a year. So sometimes it can take a facility a little while to obtain a certified operator. Our compliance staff often work very closely with facilities to make sure that they are taking those tests and obtaining that operator. I don't think I can speak to the application as a whole. If you have any specific questions about application, like specific parts of the application, I'm happy to answer that question. But Generate Fremont did provide the information that was needed to make a permitting decision in the application.
Ryan, I'm gonna go back and address a question about the facility being out of compliance. This is a draft permit. So the limitations that you see in the draft permit are proposed. It's not issued yet. We knew that they couldn't meet the proposed limits or the parameters that Alyssa outlined. So any facility that's getting limits, we need to be fair and reasonable and give them a chance to meet the limitations. So that's why there's a schedule of compliance. The facility was adamant with us that they couldn't meet the limits, no matter what they did. That's why we talked to them about the pollutant minimization program. For any of you who are familiar with how we regulate other facilities, what goes into a wastewater treatment plant, be it a municipal system or an industrial system, is dependent on what goes in because it affects the quality of what comes out. So we wanted the facility to investigate the feedstock to tell us through a plan with a schedule of compliance, what type of feedstock is causing certain exceedances of the pollutants that we're seeing in the digestate. So we did have a plan to address it. I can tell you that we had to go around and around with the facility on those requirements because we were concerned about those concentrations. The rules require protection of drinking water, so we weren't able to change those numbers. So I just wanted to be clear, they're not in violation. We haven't issued this permit yet.
So the violations that she was speaking about are the proposed?
They were not meeting the standards that we had in the permit.
In
So,
the current or the proposed?
so the agricultural use agreement is what they are operating under now. That's administered by Materials Management Division. Because of the changes in the type of digestate and how liquid the material is, the department decided that that was no longer appropriate for us to regulate them that way, which is how Water Resources Division got involved. We've only been involved in this facility. I think they applied for this permit just going on 3 years. We've been working on this particular permit. They have not asked us to withdraw the permit, so we are moving forward. I'm hoping that sheds a little light.
I was hoping, you could clarify how samples are collected from the digester to quantify digestate sampling. Are samples collected from each tank? Are they only collected from the lagoon? If they're collected only from the lagoon, is the digestate collected from the top or is it collected from the substrates at the bottom where PFAS are known to accumulate and other analytes?
So they collect the samples from the lagoon themselves and they collect from different striations in the lagoon using a baler or a ladle.
Did they submit it, did they submit the samples as composite samples then, so it only qualifies as one sample?
Yes.
Thanks. Other questions? We're gonna go to 7 o'clock for questions, so if anybody hasn't asked one, I'd like to try to make sure everybody gets at least one question asked.
So the question comes to mind, listening to this conversation, that they were found in violation of the previous permit. What is the difference, what is the difference between that permit and the new one that we're looking at now? Are you trying to take the items that they were not in compliance with and changing the new permit so that they will now be in compliance, or is it totally different?
I think it's when they initially applied for the AUA, I was up here when Novi Energy applied for it because they had I remember we're out behind the digester and they had some piles of the digestate. It was solid. It was like really fine mulch or whatever because it was the residuals from the manure that they were trying to digest. So it had a much different composition than the stuff that Generate eventually started using as the feedstock for the digester. And so that's what Christine was talking about is their process changed and the AUA didn't really fit because the AUA initially the groundwater program was part of the division that I'm in now, and that was split how many years ago when the department was reorganized. And so we retained stuff for land application for solids, whereas the liquid went to the Water Resources Division for groundwater discharge permits. And in the meantime, Generate took over the digester. And when they did that, their feedstocks changed. They went away from manure almost completely. And so it changed the digestate. And so it changed how we look at it. And that's why Water Resources is looking at it now versus materials management.
I was just gonna provide one bit, just a little bit more for you. Is it changing? Yes, different statutes, are the reason why it's gonna look different than the agricultural use agreement that they're under right now. Alyssa outlined the statute that we administer, Part 31. And so, discharge permits of wastewater, we permit discharges of wastewater all over the state. Your wastewater treatment plants, your industrial facilities, we write permits that are protective of waters of the state. So it wasn't necessarily to address violations as much to comply with a different statute. One that's aimed at protecting, in this case, primarily groundwater resources. Does that help?
Yeah, a little bit. The other question I have is, if this permit does get issued again, will permanent covers be mandated on the lagoons? I don't see anything in this proposal that says anything about permanent covers.
I'm not sure we can answer that question right now. History wise, Fred, maybe you know the covers were odor related.
Yeah, the covers were odor related, and covers ultimately did help. It was a little late, but currently they're looking to close the lagoons. So they're gonna.
But if you issue the permit, where is the digestate going? Somewhere else?
I am not certain about that.
Somewhere.
You know, I think that a lot of people are aware that, maybe there's been some talk about, you know, closing the lagoons. The way that the draft permit is currently written is based on the most up-to-date application we have. So because, we have not received an updated application saying, you know, the lagoons might not be included in their process, that's why they're still within the draft permit, will be in the draft permit unless the facility requests and submits an updated application to indicate that they will not be included in the process. I think the other thing I was gonna address is our permits do still require under Part 22 rules that they do not create nuisance conditions, which includes odors. In particular, the permit, again, like Chris says, maybe we can't address right now, it doesn't necessarily address specific covers, but it does prohibit them causing nuisance conditions.
Great, thanks. We have time for 2 more questions before we have to move on to making statements. If we don't get your question, Alyssa's contact information is up there. Please take a photo or take it down, or you can ask her at another time.
Hi, could you clarify Generate's current permit status? Are they operating under Novi's original agricultural use agreement, or are they operating under a consent order that was imposed with fines due to their violations of the AUA?
They're operating under the AUA.
And what happened with this order?
The consent order, they paid fines and penalties. I think they're out of the consent order at this point. I think that has been terminated and they're operating under the AUA.
The last question.
Put your hand up higher, Jerry.
I have 3 questions.
Three of them.
Lagoons, because lagoons isn't, it is in here. If they're gonna be removed, where are they gonna go? And if new lagoons are going in, how are you gonna monitor wells that are already bad? That's one question.
So I guess the disposal of the current lagoons, I'm gonna pass back to Fred because that is under their currently extended AUA. In terms of the situation of if there were new lagoons installed, we would certainly have to address that under our reviews. Again, the draft permit is currently written based on the application we have, which is for those existing lagoons. If they were to say remove them and install new lagoons, we would have to address that either through, them updating their application, or if the permit had been issued, it would be a permit modification request. But if they were to change things based on what they submitted in their current application, they would have to notify us and we would have to review that information.
Thank you. Fred don't have to answer anything. It's about the monitoring wells. Because if you're gonna let them use the lagoons, how are you gonna monitor those lagoons with bad wells already?
Right, so Angela, I don't know if you want to address this, but I think generally we would have to know, how was the well, or I'm sorry, how was the lagoon removed? Did it impact those wells? Did they close and plug those wells? Because then, that would obviously affect what our requirements would be. Under the Part 22 rules, there are requirements for how lagoons are lined. In particular, it is a composite liner that requires some form of base, that's clay or some other kind of geocomposite material, as well as a flexible membrane liner on top, which is generally, it kind of looks like plastic. But that, if the lagoons are lined to those requirements, we do not expect there to be any impacts to groundwater quality from those lagoons, and that's consistent throughout all groundwater permits in the state and NPDES lagoons as well.
Okay, that's not an answer, but that's okay. If on the land application, in order to monitor those, is it feasible to put in this application how they apply it? That means their equipment be equipped with GPS and monitoring systems to record to the cloud, so you know exactly what they're doing.
So, I'm trying to find the page.
That way you know if they're putting on 1 inch per acre or 1 inch per day.
So page 12 currently lays out the requirements of what they're supposed to submit to us. And that includes things like where it is being applied, the acres applied to, the quantities in gallons. Again, I think this has come up multiple times that our permits are reliant on self-reporting data. And in that case, that is part of that self-reporting data. And that's consistent throughout the state for all of our discharge permits.
Yeah. Yeah, but it can be recorded. I mean, it gets done everywhere. Another thing is the design requirements on B1 in your permit for discharge authorization by the wells. Is there gonna be a map and people told about if their well is type 1, type 2B, and how far they gotta be away from their well? I mean, in the AUA, excuse me, I have a map of theirs that's supposed to be 500 feet from a domestic well.
So they will be required to submit maps of each field that are contained within what we call our discharge management plan. That again is a document we use for multiple facilities throughout the state, or a similar document for each facility that lays out identification of the field, what's in the nearby area, including things like drinking water wells. In terms of the isolation distances, we do want those marked on the map. We do require them to, when they discharge to a field, to mark out where those isolations are. And those isolations in particular come from the Part 22 rules under a Rule 2218 permit, which is the permit category for this particular permit. It sets out specific requirements of 2,000 feet from a type 1 or 2A, 800 feet from a type 2B or a type 3, and 300 feet from a domestic well.
Thanks, Alyssa. All right, we are going to move on. First off, thank you for all your questions. Thanks for our panel for answering those questions. It's time to need to move on is a part of the evening where you'll have an opportunity to make a comment. Thanks for holding on to those so that we can have them for the hearing portion of tonight. All right, and to get started, I'm going to have a hearing statement to read. This is kind of lengthy, but this will open the hearing for us to make your statements. And I have a list of cards with me of people who would like to make statements tonight, and we can do those in order. But to start, in a little background, this public hearing will be used to take comments on the proposed groundwater discharge permit for the discharge of digestate to the ground from Generate Fremont Digester LLC. The discharge is proposed at a maximum of 10,000 gallons per day, or 10 million gallons per day, at multiple locations through Oceana County, Muskegon County, and Owego County. The next part is how the comment process will work today. I will begin calling the names of the people who have indicated they would like to make a verbal comment tonight using the provided cards. Once we go through the cards, anyone else who would like to make a comment will be able to do so, even if you do not mark that you would like to make a comment on your comment card. At that time, please raise your hand if you'd like to provide a comment. Each person will have 3 minutes to make their comment. I'll indicate when you have a minute left and when your time has expired. I'm going to add in here, there will be a clock on the screen so that you'll be able to tell how much time you have left. If I indicate that your time has expired, please wrap up your comments immediately so we can allow the next person to make their comment. Please be sure to state your name and any organization you represent prior to starting your comment. This hearing is being recorded and your comments will be part of the information that the department will consider on the proposed groundwater discharge permit. Comments received will not be responded to at this time, but will be included in the response to public comment document and part of the permit record. All comments and information received will be available in my Enviro, our online database. If you would like to make a comment but do not wish to make a verbal comment today, you are welcome to submit a written comment to the department. Written comments may be submitted online in our My Enviro database or submitted to Alyssa Inachko. Instructions for submitting comments through My Enviro and Alyssa's contact information can be found on the public hearing notice document, copies of which can be found at tonight's event. The public comment period is open until November 27th, 2024. After the close of the public comment period, EGLE will review all written and verbal comments received. A response document to comments received will be developed by EGLE. EGLE may deny the permit, approve as drafted, or approve amendments. If approved, the decision must specify which provisions of the draft amendment, provisions of the draft permit, if any, have been changed in the final permit and the reasons for the change. In all 3 scenarios, all interested parties, including everyone who was on the original mailing list, anyone provided contact information either with public comments or during this public hearing will be directly notified of the decision. All right. So if anybody else would like to make a comment and hasn't submitted a card, you have an opportunity to raise your hand. I'm going to go ahead before calling the first name and bring up a timer so that you'll know how much time you have left. It's going to be 1 comment per person to make sure that everyone has a fair opportunity to make a comment. All right, well, there's your timer. All right, so the way we're going to do this, you'll see a microphone at the front of the room. I'll call your name. Please come up. The timer will start once you start your comment. I'll let you know when you have about a minute left. And then when your time is up, we'll go on to the next person. All right, so first up is Alexa Chapman. So Alexa, you're invited to come up and begin your comment.
Hi. Good evening. My name is Alexa Chapman. I'm a mother, speech language pathologist, and a private practice owner, and a proud 2nd-generation Fremonter. I have the privilege of serving the children of the families in Owego County through my work, and I'm here tonight as a deeply concerned resident to oppose the groundwater discharge permit for Generate's digester. Fremont is more than a rural community. It's a cornerstone of Michigan's agricultural and natural heritage with over 800 farms, hundreds of lakes and streams, and thousands of acres of protected forests. Our economy and way of life depend on clean water and healthy ecosystems. Allowing this permit to proceed without rigorous oversight risks contaminating these resources. It threatens tourism, agriculture, and our family's well-being. If our water becomes undrinkable and our land toxic, who will bear the cost? It will not be Generate Upcycle. It will be us, the residents of Fremont. I urge Eagle to reject this permit and demand a comprehensive hydrological report and stricter monitoring requirements. Our community cannot afford to gamble with essential resources like our water, air, and land. Fremont deserves better than corporate negligence masked as progress. As someone who has worked with children impacted by the Flint water crisis, I have witnessed the devastating lifelong consequences of environmental negligence. Flint schools are still struggling to support children harmed by lead poisoning with cognitive and developmental injuries, an ongoing reminder of what happens when profits are prioritized over people. Fremont deserves better. When government agencies and healthcare institutions fail to have real skin in the game and aren't held accountable, local communities are left to fight these battles alone. Our children's safety is a non-negotiable. Every parent in Fremont deserves to know their child is drinking clean water and growing up in a safe environment.
1 minute left.
Eagle has the power to prioritize people over profit and restore confidence in the systems meant to protect us. To my neighbors, let's come together and make it clear. Our children's future, our community's health, and our natural resources are worth protecting. Our Fremont deserves nothing less. Thank you.
Thank you for your time. Actually going to call 2 people at a time. First person will come up, the second person will know that they're next, and then that way we'll try to minimize the walking time. Emily Klopp, and then after Emily is Dorothy Paris. And I should mention, if you run out of time making your comment, we are going to provide the other ways to make a comment at the end of tonight's hearing.
Thank you. My name is Emily Clapp. My husband Nate and I built a house on a beautiful 10-acre piece of land in Holton Township 17 years ago. And this is where we have called home since. This is where we have raised our 10-year-old son. I have worked for the local hospital system for 10 years, serving my community by helping to improve the health of fellow community members. Our property is primarily wooded with Cedar Creek running through the middle. This property has been our sanctuary. We have enjoyed seeing a variety of wildlife, including great herons, green herons, a variety of frogs, toads, salamanders, mink, trout, salmon, owls, hawks, fox, and of course, white-tailed deer and turkey. We get great joy from observing this wildlife, as well as the ever-changing flow of Cedar Creek. I attribute much of the wildlife we have seen to the creek. Wildlife needs water and congregates to a water source. Within the last several years, particularly since the digestate has been spread, I have noticed a decrease in this wildlife, particularly the frogs and fish. When my son was younger, he used to play in the creek and catch frogs. There were plenty to be had. I'm gonna fast forward. When we walked our paths through the woods, I would hear frogs jumping back into the creek to my approach. I don't hear those sounds very often anymore. I don't see as many frogs at the edges of the creek. This is concerning to me. As is well known in ecology, amphibians are the harbingers of ecological change. If I am seeing less frogs, less wildlife, why might this be? We have not experienced a large population growth in my local area to account for these changes. The most significant change to the area in recent years has been the digester lagoons and the spread of digestate.
1 minute left.
The digestate spread has created nothing but problems for the community. There have been spills and horrible smells. My husband and I grew up in rural Michigan. We know that some smell is associated with farming. However, the smell from digestate in the lagoons is not just a farm smell. It is putrid, it is permeating, it smells toxic. I am concerned for the health of my son. my family and friends who visit and drink our water, for our community members and the wildlife that depends on the health of our waterways. Toxins like PFAS and microplastics, not to mention the volatile gases emitted from the digester and the lagoon contents, have already been identified in the digestate, and what has been done about this. To my knowledge, not enough. If we as a community continue to allow these toxins to be spread, we will pay in our health and quality of life as well as our children's. I am asking that this permit not be granted and that the digestate is no longer used in our communities.
Sorry, we're gonna move on.
Okay, thank you.
Thank you for your comment. Dorothy Paris, and then after Dorothy is Kathy Morris.
Hi, I'm Dorothy Paris. I've lived in Fremont for 35 years. Before that, I was a resident in California. My sister is a city engineer for Twin Falls. We talked a lot about the digester, and initially I was really positive about it. But it is clear to me that the lagoons are a source of issue here, and that to me, it confounds me that you would accept a permit that, when most of you seem to be aware that the lagoon will be in the process of being closed right now. And so you're going to accept a permit and maybe approve a permit with a whole very large, very problematic section of the permit missing. That's my unprepared part of the statement. My prepared part of the statement is that this permit allows for the digester owner to do the self-sampling of digestate, soil, and monitor wells. Monitor wells are a whole nother issue. Given the fact that the safety of the area drinking water is at stake from this digestive spread, a third-party consulting firm listed on the Eagle Consultant Directory should be the one who's taking the required samples, not the owner, who has every financial incentive to falsify their findings. And these samples should be submitted to an appropriate independent lab. We don't ask food companies that are in violation or have listeria outbreaks to do their own sampling. They have to have an independent person do that. Why would we do different with our drinking water? Current lagoons, which we now know are to be closed, had multiple monitoring wells placed around one of them to assure no leakage. However, digestate was also spread in the fields in all directions surrounding the lagoons. The new permit should disallow any digestate spread on fields within the Eagle established safe distance from the lagoon, so as not to corrupt any samples that you guys take to monitor whether there's lagoon seepage. Okay, thank you. And currently there is no requirement for the digester owner to disclose the sources of their waste stream. There was a biohazard in the food waste, or if there was, God forbid, a bioterrorist attack, you'd have no way of figuring out what was going on, what was in the digestate, what was polluting the waters.
Right.
But most of all, I request that you reject this permit until it is complete, or at least require a modification that indicates what's going to happen with new lagoons if these lagoons are in fact being closed. It seems to me just completely insane that we would be accepting a permit that it doesn't have this large and very important component to it. Thank you for your time. Really appreciate you guys all coming out here tonight and listening to us.
Hi, my name is Kathy Morrison. I'm a farmer, a former teacher and a farmer in the Fremont and Holton area. As written, this permit will not assure our community that our children and grandchildren will be left with the precious legacies of productive soil, safe drinking water, clean creeks, rivers, and lakes. Our farm received a 9-sentence letter from Generate in 2019. They used the word organic 9 times. Most people think of organic as being chemical-free, pesticide-free, but by definition, it just means that it's from living matter. So in theory, a digester owner could take something soaked in Agent Orange, put it into a digester, and boom, out comes organic fertilizer. And this is like biogas industry tactic 101. This is not just here. I hear this from people who live near digesters all over the US and even in other countries. So because of this, the current application says that they have over 300 fields that they've signed contracts with the landowners. So new contracts need to be entered into with whoever ends up with this digester. So the old agreements need to be destroyed so that there are no agreements until a new owner is in charge. The likely presence of PFAS and microplastics should be disclosed, as well as a entire chemical analysis be provided to the landowners that enter into these agreements. They have the right to know what's in the digestate, because the new digester owner, much like the old one, will probably just tell them about the nitrogen, the phosphorus, and the potassium, but not about what else is in that digestate. Landowners that live next to the fields that are spread on should also know what's in the digestate. So they should get certified letters sent each year with Eagle template language, including a definition of digestate as wastewater from a biogas facility, a copy of that same chemical analysis, the required setback distance from their well, so they know if their well is being protected. And they should have the phone numbers of contact people like the digester owner, Eagle staff that they can ask questions of, and the polluting emergency alerting system hotline, so they can report witnessed accidents. This groundwater permit will be a blueprint for food waste digester permits in our state. The biogas industry is ready to pounce on states with weak environmental regulations. They're watching us tonight. Eagle must allow zero wiggle room for this industry to turn rural America,
Sorry, we're gonna have to move on to the next person.
rural Michigan into their dumpster.
Next up is Susan Wendt, and then after Susan is John Morrison.
Hi, my name is Robin Alexson. I am signed up, but Susan left and she left her statement with me. This digest has been sampled and tested many times, yet this permit has carved out special allowances to have higher than usual limits for many of the chemicals it consistently exceeds. Both Eagle's own geology studies showed high levels of aluminum, ammonia, chloride, cyanide, iron, manganese, sodium, nitrogen, and phosphorus. The application for this permit required a feasibility of alternative study, but Generate instead provided a 2-sentence study. I'd say we can cross that study off the list and skip right to whether the permit allowing for higher than standard toxins will protect public health, safety, welfare, and protect our natural resources. It's highly unlikely right now that Eagle is being protective of us by allowing deviations from the standards. In fact, according to the state's own rules, concentrations of aluminum, iron, manganese, and sulfates are never supposed to exceed standard levels. The digestate has consistently tested high for most of these potential toxins. In fact, aluminum in the digestate has at times been 146 times the allowable discharge concentrations. Aluminum is linked to many neurological diseases and is particularly a risk for developing infants and children. However, if these toxin levels are high, the permit allows for a source evaluation and reduction plan, then a corrective action plan, and finally, a schedule of compliance for discharge conditions. The total timeline on all these corrective actions is 5 years. So the digestate could, in reality, be spreading for 5 years before it ever ends up meeting the safe standards set by the state. This digestate will be spread near our drinking water. It will be spread where it can run off into lakes and streams. it can be spread where it will build up in area soils, eventually compromising the health of area farmland. This is an outrage. Many of us here are asking you to deny this permit. Thank you.
Next up is John Morrison, and after John is Becky Cook.
My name is John Morrison. My farm has been in my family for 158 years, and I am concerned about the welfare of my community, which would obviously entail just health and safety. As a farmer, I'm aware of all the recommendations and restrictions of good farming practices, chemical use, and I obviously do not want to poison my family, my neighbors, my customers, or my land. So it's an obvious question. Would any of you want your land polluted?
No.
Would any of you want your water, especially your wells, contaminated?
No.
So it's an easy question. It's an easy answer. What we need to do is make sure that no one, whether it's a neighbor or some large faceless entity, come in and pollute our land and water. And so this is what we need, or this is what we should want and expect, that our governmental leaders and all the agencies at all levels make sure beyond any doubt that any action by a person or organization will not jeopardize the health and the future of our community. And so I would say, in this case, I would want Eagle to withdraw this permit or not allow it. And so I say again, our government officials have the duty and the means to protect the health and welfare of the community. But if they do not do so, in blatant disregard of facts, then I hope the people of the community would use the legal system to obtain some kind of protection and satisfaction.
Becky Cook, and after Becky is Carrie LeSueur.
Hi, I'm Becky Took, and I live in Fremont, Michigan. I raised my family here, and I want to talk a little bit about the nitrate in the digestate. The Eagle geologist report created for the groundwater discharge permit relied on nitrate maps made using samples taken between 1983 and 2003. Since then, the creation of those maps, that creation of the maps, hundreds of millions of gallons of both manure and biogas waste water have been spread near the area wells, greatly increasing the risk of nitrate contamination. We deserve better from Eagle than outdated data. Eagle and Generate's own lab reports prove that the digestate has excessively high levels of nitrogen that can lead to nitrate contaminated wells. High nitrates in drinking water can cause a multitude of health concerns, including, disturbingly, that high levels of nitrate are most serious in infants. Those high levels can reduce the blood's ability to carry oxygen, causing the baby to appear polluted. They can also cause rapid heartbeat, shortness of breath, nausea, diarrhea, lethargy, loss of consciousness, seizures, and even death. Thousands of people rely on private wells for their drinking water in the 3-county area where the digestate has been spread. Their water quality matters, as does the water quality of their children and their grandchildren. Fremont is the home of Gerber baby food. The company's motto is anything for baby. Please do everything for baby and withdraw the permit to spread digestate. It holds no assurance that it will protect the people of our area from the threat of nitrate polluted drinking water.
1 minute left.
And just as a little aside, it really bothers me that even if you know that something is bad about what is in the old permit, you can't stop it. They are allowed to continue with doing what's wrong until the new permit takes effect. That really bothers me. They should be stopped right away.
Next up is Carrie Lesueur, and then after Carrie is Thomas DeVue. Sorry if I'm mispronouncing any of your names.
Thank you for being here. I am Carrie Lesueur, Legal Director at For Love of Water, a Traverse City nonprofit that works to protect water quality, access, and affordability in the Great Lakes Basin. Concerned local residents asked us to review the Fremont Digester draft groundwater discharge permit. I drafted the coalition comments you received. The Michigan Administrative Code spells out what's required in an application for a groundwater discharge permit. Tonight, I'd like to talk about just one of many requirements, an evaluation of the feasibility of alternatives to discharge to the groundwater. Feasibility includes the practical ability to implement the alternative and a comparison of the cost of the alternative to its benefits. The rule requires an analysis including at least minimizing the volume and toxicity of the wastewater, recycling wastewater, connecting to a municipal sanitary sewer system, and discharging to surface water. Alternatives must be considered for minimizing the volume and toxicity of wastewater, such as equipment or technology modifications, process or procedure modifications, reformulation or redesign of products, substitution of raw materials, improvements in housekeeping, maintenance, training, or inventory control. The rule also requires analysis of specific treatment methods for various pollutants identified in the Fremont Digester's digestate. This is the law. What did this community get from Generate? 2 sentences. We do not discharge to the groundwater. A feasibility of alternatives to discharging to the groundwater is not applicable. In other words, Generate did not provide the feasibility analysis required by 2 sections of the Michigan Administrative Code, and Eagle accepted the permit application without this analysis. This is more than a rules violation. It's a violation of the Michigan Environmental Protection Act, which implements the language in the Michigan Constitution. The act says, in administrative licensing or other proceedings, and in any judicial review of such a proceeding, the alleged pollution, impairment, or destruction of the air, water, or other natural resources, or the public trust in these resources shall be determined, and conduct shall not be authorized or approved that has or is likely to have such an effect if there is a feasible and prudent alternative consistent with the reasonable requirements of the public health, safety, and welfare. Michigan case law recognizes Eagle's duty to perform adequate review and consider the range of feasible and prudent alternatives that would avoid or minimize environmental damage. The permit application as submitted by Generate is incomplete under Michigan regulations, common law, statutes, and even fails to uphold constitutional protections for natural resources. We at For Love of Water strongly urge Eagle to reject the application as incomplete and suspend any further consideration of a groundwater discharge permit for the Fremont Digester until a fully compliant permit application is submitted. Thank you for your time and consideration.
Thomas DeVue, then Leah Paul after Thomas. Name, DeVue, I apologize. How about D-A-M-E, name? That might be it. You have to confirm P-E at the end, probably all kinds of things.
Hello, thank you. My name is Thomas Dane. I'm a retired professional engineer. I was a wastewater certified operator. I worked as one of your counterparts for the state of Wisconsin. I issued many NPDES permits for both municipal and industrial discharges in the 5-county area. I inspected their facilities, usually unannounced. I brought swift enforcement action against violators, and I helped train their operators. I also worked with US EPA Region 9. I also issued NPDES permits and inspected drinking water systems on Native American lands throughout Arizona and Wisconsin. And I've reviewed an awful lot of discharge permits in my day. And this is right up there with one of the top 2 worst. So thank you for that. This is not food waste, although the discharger and maybe people at Eagle want us to believe that. This is not the water from baby food. This is industrial waste.
Yes.
It contains cancer-causing chemicals, as you well know, and they well know it because they've got the test results like toluene, benzene, and all kinds of other VOCs, volatile organic chemicals, with those names like methyl or octo or methylene chloride, and other things that we can't pronounce. We don't want that in our food, but it's in this waste, and you know it. The discharger applied for a permit for 125,000 gallons per day. Somehow along the line, the permit says if it's issued, they can discharge 10 million gallons per day. Where did that come from? I read the reports from Ms. Strong, you're up there. It seems like you based your recommendation on, given the high levels of contaminants, industrial contaminants in this waste, they should be limited to 1 inch per year. Somehow along the way with your colleague, Mr. Chatterson, determined, well, it might work out, shouldn't pollute the groundwater as long as it's limited to 1 inch per year application. Somehow, again, along the way, as my comment said earlier, the permit says you can discharge 1 inch per day. As our good folks at Flow said, there's no feasibility study done, there's no sampling analysis plan, there's no source evaluation reduction, there's no discharge monitoring plan, there's no groundwater monitoring plan. I work for government, I know what you're doing. You want to get this permit shoved through and then wait while they're discharging for the reports to come in, and you'll comment, and we won't have any ability to look at the documents, to comment on them in a public forum like this. The permit will already be issued at 10 million gallons per day. I recommend if anybody is in here that's going to allow this waste to be on their property, you better have some darn good liability insurance. And for those of you that are next door where this stuff is going to be spread, I recommend you invite good people from Eagle and maybe Digestate. Have them bring your family over on a nice warm day in July or August and have a picnic outside. Feed their kids a lot of your drinking water from your well. Thank you very much.
Leah Paul, after Leah is Todd Blake.
Hi, my name is Leah Cunha-Palm. I grew up in the area in Nuevo specifically, and I'm currently a resident of Fulton. I have a bachelor's in biology and environmental studies. Was previously an environmental consultant for an environmental engineering firm, and I am currently a Michigan certified wastewater operator. I have concerns about the analytical parameters previously tested for in prior soil, water, and digestate samples, as well as the guidelines set forth in this draft groundwater discharge permit. In the soil sampling section, the permittee is to collect and analyze soil samples for all lands to receive digestate within 4 years of desired application date. The permit should require soil samples to be collected prior to digestate application under this permit and to establish background levels in the soils and to determine applicability of the digestate on these lands. The fields which do receive digestate should be required to resample soils every 2 years. Some of these fields have already had digestate applications and potentially have elevated metal concentrations, VOCs, or PFAS in them. Additionally, the parameters required for soil sampling in the permit are only Bray P1 available phosphorus in the soil, sodium, pH, and cation exchange capacity. At a minimum, the soil sampling of the proposed land application site should be analyzed for all parameters required of the digestate. However, I additionally propose that before using digestate for any applications, the digestate be tested for fiber content, fiber composition, chemical oxygen demand, biological oxygen demand, ammonium, nitrogen, phosphorus, and potassium, micronutrients, full panel of VOCs, all heavy metals, microbial load, and pathogens. Analyzing for the major and minor elements of the digestate will allow for decisions to be made with regards to whether it is suitable material for land application and does not exceed regulatory limits. The digestates originating from industry process streams and mixed solid waste streams, such as feedstocks needing deep packaging, should be tested for impurity content, plastic, metals, and glass and gravel less than 2 millimeters in size. Moving on to the groundwater monitoring section, I am concerned about the comprehensive examination and sampling of the groundwater. Firstly, the groundwater flow in the area of the lagoons was determined to be to the south-southwest. However, no wells were set along the perimeter of the southern lagoon, down gradient of the northern lagoon, which had concerns of improper installation and leakage. Additional wells, 2 at a minimum, my recommendation, should be installed along the western and southern boundaries of the southern lagoon. Additionally, only 4 of the 6 monitoring wells installed were sampled. The parameters set for the groundwater samples within the permit do not include a full panel of VOCs or PFAS analysis. Also, groundwater monitoring should be conducted quarterly with the requirement to submit a request after 2 years of sample collection to reduce sampling occurrences. I would also like to add that these monitoring wells do not establish accurate baseline levels for any analytes in the area of groundwater, as the lagoons are surrounded by fields which have had multiple prior digestate applications. I'd like to thank all the departments in Eagle for their time and work on this draft permit, and I look forward to seeing our community concerns addressed in either denying this permit or a revised draft. Thank you.
Thank you. Next up is Todd Blake, and after Todd is Carrie Higgins.
Thank you for taking the time here to listen to everybody. Obviously, there's a lot of concerns here. My name's Todd Blake. I'm city manager of Fremont from the beginning, and still, we are very supportive that, in theory, this digester and the way it was supposed to work is a great thing. It's creating energy. It's reducing food waste, carbons, all kinds of things, and that was going to be fertilizer. Obviously, from what you're hearing tonight, the concerns of the landowners and the landowners nearby, where it's being spread. These are very legitimate concerns. If this permit is approved, I would hope that you're listening specifically to a lot of great suggestions here tonight with regards to making sure that the certain testing and quote requirements are being put into it. On maybe a lighter note, the city has a conversation with prospective potential buyers of the digester who are interested more in putting an industrial pretreatment process. So if that is the case, if it should happen, that would, I think, take away a lot of the issues and concerns. So that news is somewhat being shared as hopefully a potential good news, because that is, as was mentioned by the, I forget what your name was, but that's a process that certainly could come into play and then reduce and eliminate most of the concerns here. But that's all I have.
Thank you. Next up, Carrie Pickett, and after Carrie is Andrew Salasina.
Hi, my name is Carrie Pickett. The Fremont Digester has not been good neighbors with smells over the lake when in operation. Operating under the incorrect permits show their level of care towards community. Providing incorrect information to the public as to what is actually in the lagoons regarding PFAS has also shown our community that we can't trust the information that they're giving us. It's my understanding that only digest from the Fremont Digester was to go into the Holton Lagoons. So how did the PFAS get there to begin with? Will Eagle please require testing for PFAS and microplastics in any new digester wastewater permits? Another question that I had that I didn't get to ask was, I saw on your information that this permit is good for 5 years. That's a long time.
Yes.
Especially for a company that we don't know what their role is going to be like here in our community. Is it possible to grant a 2-year permit so that we as a community can start to at least figure out, are they going to play by the rules or are they not? That's all I have. Thank you.
Andrew Salasina, and after Andrew is Robin Asbrookson.
That deviate from those listed on this permit application. This district permit should not go with the sale of the facility. We count on Eagle to require any future owners to apply for their own permit and not be granted automatic transfer of this permit. Permit calls for records for all groundwater related activities to be retained for 3 years. This is not at all an appropriate length of time. The agency can and should require a longer record retention time on both digester wastewater and monitor well testing data. Perhaps more appropriate would be for 3 years after closure of the digester. The permit does not demand that the applicant hold any kind of pollution liability coverage or provide an environmental security bond. Will it be up to the farmers, the landowners, the well owners, taxpayers to pay for cleanup costs in case of a pollution event?
Thank you. And after Robin is Philip Clark.
I'm Robin Oxon. I already read a statement, but I would like to say thank you to all of you for coming up here and facing all of us in person. I'm a lifelong resident. I grew up in Bolton, then my family moved to the big city in Fremont. And, we've raised our children here. I taught at White Cloud. So I've grown up drinking the water in this community. It just breaks my heart to think of the fact that when I read off the names of all those chemicals that are being included right now or that are being dumped right now into our fields, it just breaks my heart to think of the fact that my friends, my family, my neighbors, my grown children and my grandchild are drinking well water that has these potential chemicals in it. The question I wanted to ask, and I didn't get a chance to, is if PFAS has been found in the lagoons and they're closing these lagoons down, who's responsible for cleaning up those lagoons and taking that contaminated soil away from our community? Again, I would really hope that all of you would reconsider your actions here today and deny or relook at this permit in terms of the length of time that you are proposing to extend it to. Thank you.
Thank you. Next up, Philip Clark, and after Philip is Gina Hall.
Hi, Philip Clark, Holton Public Schools. On behalf of the Holton Public Schools Board of Education, we request that the following concerns be addressed and considered in any application permit, which encompasses fields near the school district's wellhead protection zone. Holton Elementary's wellhead protection zone was identified for potential contamination by the hydrogeological evaluation performed by Eagle in 2023. Naturally, the school district is highly concerned of any potential contaminants that could impact the safe drinking water source consumed by our students, staff, and visitors at the elementary school. Should any permit be approved by Eagle for the application of bioproduct on local fields, the permitted zones should not include any wellhead protection zones, and these areas should be clearly identified and understood by the applicator. Even if any permit is considered in or near the protection zones, the school district respectfully implores Eagle to conduct an adequate hydrogeological investigation first, determine whether any risks exist in manure application, lagoon storage, or other permitted activities in the vicinity of any wellhead protection zone. School district believes that unless such testing and investigation can reasonably assure that its wellhead protection zone is protected from any permitted activities, those activities should not be allowed to proceed. The current permit does not appear to provide that degree of assurance by requiring a prior investigation. In addition, we believe that any investigation and monitoring must include testing and monitoring for per and polyfluoroalkyl PFAS substances as an added precaution. Enforcement of the permit needs to include monitoring to ensure adherence to the permit's requirements and a clear process to report concerns. The opportunity to be proactive in the protection of the water source, our drinking water source, is only available for a limited time before it becomes too late.
1 minute left.
Should contamination occur, resulting in unsafe drinking water for district students, staff, and visitors, obviously the impact would be detrimental to the learning environment, impact the overall health and wellness of children, and jeopardize the trust we all sacredly hold as community servants. The Holton Public Schools is grateful for this opportunity to address Eagle and say our piece for the record. And, you know, take this opportunity to keep our schools' drinking water safe and well protected. Thank you.
Next up is Gina Hall, and then after Gina is Gloria Switzer.
Good evening. My name is Gina Hall. I do not own a farm that uses the digestate or interact with the digester directly, so you may be wondering why I have concerns about the permit process. I do, however, buy locally grown produce from this area. This produce from farmers may be affected by the
All right, for future reference, I'll turn the microphone down first.
No. I know I'm at 2 minutes and 50 seconds with this.
Okay.
Can I start over?
Yeah.
All right.
I just reset.
All right. Good evening. My name is Gina Hall. I do not own a farm that uses the digestate or interact with the digester directly. So you may be wondering why I have concerns about the
Sorry. It's the sound system, so sorry.
Here.
every time I get closer, it starts.
We'll swap you out, Mike's, yeah.
All right, good evening. My name is Gina Hall. I do not own a farm that uses the digestate or interact with the digester directly. So you may be wondering why I have concerns about the permit process. I do, however, buy locally grown produce from this area. The produce from the farmers may be affected by the wastewater that has been spread out into the fields I am buying from. Another reason for my concern is from the common knowledge among the concerned citizens is the runoff from the digestate. This is spilling into other farmlands, drainage ditches, artesian wells, and which is affecting the soil and in turn the drinking water in a few years. From my understanding, the company that owns the digester now purchased the facility back in 2017. The company acquired the already existing permit. That permit should not have been transferred over so easily since this company produces a different end product than the previous company. I am also concerned over the fact that the substantial evidence of the current permit was not followed properly by everyone, including Eagle. In the end, the AUA permit should never have been given to the current company. I'm going to assume that this company, Generate, is going to be handed the groundwater permit that should have been the original permit this company applied for. So I would hope, with that being said, everyone can take into consideration how we, the concerned citizens, feel about that. First off, I would like to make some requests that I feel that we all would like to see as changes to better our community. More testing of the digestate. I know that the testing has been skimped on or not even done properly. We want to know what is put out on these fields every time it's spread. Next, there have been too many unreported runoffs or spillovers. When things go unreported, it is simply hiding the bad things that has happened. We should know and keep track of the mistakes that were made and in turn fix what needs to be fixed. I understand every company wants to keep up a good appearance, but no company is perfect. This shows every time a name is changed that a company goes through. Working together, reporting spills and performing more tests of what is being spread in our fields and following protocols from our small government will make this digester better. I heard a rumor that the current owner of the facility intends to sell its facility to a new company. Like I said, this is a rumor since I do not know the truth about it. My point is, with every sale, every name change, every change that with the end product within the digester, there needs to be a new permit drawn up. In short, we live here. Most of us eat the food that grows or is raised here. We know the shady things that are going on and we have come together to speak out about it. We want more transparency with these permits. We want more accountability from both sides of these permits. We are aware that the people hate the digester. Maybe it's from all the mistakes they are made and not corrected. Some of us want to like the digester, like myself, but I want to see the permits actually being followed, just like the rest of us that need to follow through with ours. I appreciate being heard, and not only do I look forward to seeing improvements in our community, but so does my family and our children. Thank you.
Okay, sorry about the microphone issues. Next up is Gloria Switzer, and after Gloria is Elizabeth Moy.
Good evening. I am Gloria Switzer. I've lived in Fremont for 53 years. I appreciate you all being here in the evening. I'm sure this is overtime for you. I appreciate you being here. Tonight we have heard two citizens who spoke here say the words certified wastewater operator, and that is my concern. Right now, the permit application lists no certified wastewater operator. And Michigan has clear regulations regarding the need for such a license to assure safe operations.
The Michigan rules that we have outline the processes for obtaining a wastewater certification, renewal of certification, and revoking those certifications if needed. The permit provides no proof that a Michigan certified wastewater operator will be established at the Fremont Digester. Really? Has Generate contracted at all or connected to the district compliance staff to discuss this requirement of the wastewater treatment and operator? But more importantly, since Generate plans to sell the digester, that's what I've heard, the language needs to be added to that permit, if there is a permit, maybe not, but requiring a Michigan certified operator. And that will be established prior to any continuation of the digestate being produced or land applied. So will Eagle please change the language of that permit to require the necessary proof of a certified wastewater operator before issuing a blank permit that is automatically transferable to new owners without proof of a state certified wastewater operator. Thank you for your consideration.
Thanks for your comments. All right, next up is Elizabeth Moy, and then after Elizabeth is Jane Strachan.
Hi, I'm Elizabeth Moy and a lifelong resident of Fremont. The permit makes no mention of testing for chemicals of emerging concern, such as microplastics, which have a host of environmental and health effects. Microplastics are known to be in our food supply, depackaging food waste, as is done at many food waste digesters, adds more microplastics into the digestate. We do not need plastics sown on our area land and near our creeks, rivers, and lakes. Eagle's own geologist recommended testing for PFAS, yet the permit does not demand it, and this should be required, especially given the fact that under Generate's ownership, 2 PFAS chemicals were detected, yet they did not choose to halt land application, nor was it halted by Eagle. Both liquid and solid portions of the waste should be sampled and tested. These forever chemicals are persistent and bioaccumulate in the environment and in the human body, causing health problems such as kidney, breast, and testicular cancer, endocrine disruption, low birth weight, and increased heart disease. PFAS forever chemicals from wastewater residual spread have forever ruined farmland in this state and beyond. We do not need a repeat in Muskegon, Newaygo, or Oceana counties where this is spread. Will Eagle please reject this permit until it can be written with more concern for our health and well-being? Thank you.
Thank you. Before we move on, just to give a time check, as mentioned before, we have to be out of this room a little bit later on, so we need to end at 8:10 today. I have about 9 commenters left, so I'm gonna put the other ways to make a comment on here so that you'll have those other ways in case you would like to write them down or have them available and didn't get a chance to make a comment tonight. So next up is Jane Strachan. And after Jane is Alan Yeager.
Hello, I'm Jane Strachan, a resident near Fremont Lake. In the 1970s, we all were poisoned by PBB. Some of you are not old enough to remember that, or having had to experience it. There was not enough testing. That's my entire statement. Would you please do proper testing to ensure us that we will not be poisoned by the next owners of the waste management. Thank you.
Jagger. Then after Alan is Dustin DeLebeau. Dustin DeLebeau.
Alan Jagger, Holton Township Supervisor. Why not monitor all wells that are around the parcels this stuff gets put in? Our township people want to know what's in their well, and we're having them having to pay for it and to see. So once a year, we should monitor anywhere this stuff is put, wells surrounding them people's wells should be monitored. I think all pieces of land that this stuff is put on should be, have a soil sample once a year, so that it's monitored. We should have a baseline already, because most of the wells in a 4-mile square over there already won't pass because of nitrates. So we know that it's bad already, but there's so many wells tested in there, we're already having a lot of problems. Holton Township doesn't get any money for this, so no tax dollars whatsoever come to us. Fremont gets all of it, we get nothing. We take the possibility of getting the pollution. This is an issue. No one from Eagle or the digester has ever come to talk to Holton Township Board, ever. You guys, you can do whatever you want. We have zero say in this. Up until tonight, we had never heard that the lagoons were even thinking about closing. So we didn't even know that. I don't know it. So, I mean, I got people, all of our constituents that we have to answer to all the time. We can't answer anything because we don't know anything. So they have to come to you. And I do believe that more communication with the township so we can answer some of their problems would be a good thing. Thank you much.
Thank you for your comment. Okay, next up is Dustin DeVoe, and after Dustin is Brent Maloney. Go ahead, Dustin.
Good evening. I'm Dustin DeVoe. I serve as the Family Engagement Specialist for Holton Public Schools. In addition to the comments submitted by the Holton Board of Education and the Superintendent, I also want to express concerns on behalf of the families that we get to serve. Protecting our schools' drinking water is critical to our students' success, as mentioned before. This extends to the water in their homes. For our families who may be impacted by any contamination risk due to the application of this biowaste, they deserve protection too. Any approved application permit should provide resources to families to obtain water testing resources that any contamination is found quickly. For many of our families, purchasing a water testing kit is not an option financially. With the known risk, potential PFAS, contaminants, and runoff exposure, all the things that we've been mentioning throughout this whole entire night, the families in our community must be equipped with the appropriate tools and information to protect themselves. We matter. Our community is best when we look out for one another. Together, we can keep our families safe while also supporting local businesses. Thank you for your time and consideration on this matter.
Thank you. Next up is Brent Maloney, and after Brent is Sherry Claflin.
Hi, I'm Brett Bartolomeo, and I just think it's really a disgrace that a freshwater state and being Eagle, the Department of Environmental Great Lakes Energy, has the problem of letting big money get in the way of polluting our land. And that's exactly what it is. It's big money. It's corporate going, hey, we got all this digest, we got this chemical, we can't get rid of it anymore. We can't build these holding ponds for it, take it and put it anywhere. Can somebody get rid of it for us somewhere? Oh, you want to? Okay, we'll give you $500,000. Go ahead, find somewhere to put it. Okay, we'll do that. We're going around. We got a farmer here. Oh, the farmer. They can put it all over the place. Nobody will care. The farmers can do whatever they want. The local farmer in charge of most of this digest has been fined so many times that no one even knows. They don't care. You guys find them. You find the farm that's in charge of most of this digest. They've been fined numerous times by you, and they're still allowed to do it. So there you go.
Sherry Claflin, and after Sherry is Miss Theodora Snyder.
I'm Sherry Claflin. I'm an educator. I've been an educator for 30 years. I teach at a local junior high, and I also teach college classes at a local community college. So my concern is this: when we have runoff, we have a lot. So there is a lot of evidence right now that proves that climate change is affecting our rainfall patterns here. And when our rainfall patterns here increase, we get runoff. It goes into our lakes, rivers and streams, ponds, wetlands, and eventually makes it into our groundwater system. So as of today, the carbon dioxide level was 424 parts per million. Over the last 800,000 years, it's been around 300 parts per million, which means that our overall temperatures are warmer, which also means that when we have warmer temperatures, there's more water vapor in the atmosphere, and that causes more rainfall. On September 24th this year, we had a rainfall event over 24 hours that caused a massive flooding event where Muskegon County had 4.42 inches of rain in one 24-hour period. North of Muskegon, it was 9.8 inches of rain in one 24-hour period. In Fremont, it was 3.8 inches per rain. I want to draw our attention to this because this caused massive amounts of flooding and runoff, and there was digested on the farm fields, which all was caused to run into our wetlands, our streams, our rivers, and our lakes. So knowing this, your permit allows for digested to be spread when the forecast is 1/2 inch of rain in the next 24 hours. That rain event, which is not usually typical, but are going to be more typical in the future, those events are going to happen more. Thank you. Those and more events are going to happen more often. The rainfall event was for 3/4 of an inch of rain. We got 3.8 inches in Fremont. All of our rainfall patterns here are increasing. That's from NOAA, that's from the National Weather Service, and our local offices in Grand Rapids. So I want to say this, of all the very high-risk areas and fields in Nuevo County, Oceana County, and Muskegon County, there are 38 fields that are of extreme high risk of contamination, with multiple wells around every single one of those fields. So as we look at those extreme rainfall events that are now occurring much more at a much higher rate than in the past, because climate change is increasing the amount of water vapor in our atmosphere, adding to our storm intensity. Typically, 1 inch of rain yields 27,000 gallons of water per acre of land. The rainfall.
Sorry, we're going to move on to the next person.
Okay, thank you.
This be yours, Snyder. It's going to have to be our last commenter.
Good evening, ladies and gentlemen. Regarding the reopening of the digester, I feel it should be under the strictest, stringent supervision. Let me explain some of what we have suffered. We're confident the close proximity to our home to the digester lagoons have either caused or contributed to our poor health. I have a paper trail confirmation. It's a known fact that lagoons have serious effects, not only on health because of known PFAS, but enjoyment of life. They've impacted us financially, mentally, physically, and emotionally.
We're sorry.
No
Your
fresh
conference
air
is ending
inside
now.
or
Please hang up.
outside. I'm very concerned what toxins we've been breathing, cooking, drinking, and bathing with over 5 years. I'm now wondering if they're the cause or contributed to my newly diagnosed cancer diagnosed this past June. Our health has deteriorated extensively since the beginning exposure to the toxic lagoons. Eagle brought out a monitoring machine for reading toxic levels. Once reading it, they said, quote, "These levels can't be right." They decided to leave it over the weekend, but came and removed it early the next day. Later asking Mr. Unseld, just what is the field to the north of the house, he told me a wastewater system, so to speak. I asked, "You mean like Muskegon's wastewater?" He replied, "Similar." Have you any idea how comfortable that made me? It has caused us much unfair stress, duress, poor health, and thousands of dollars. The quality of our water has deteriorated over the years despite the water filtration system we purchased and still paying on. Presently, I can't verify the cause of our poor water, but felt this important enough to be noted. We are now back to buying bottled water for drinking. Thank you all very much for allowing me to speak. This has been a major concern.
Thank you for coming.
I have a brief closing statement to read before we close out tonight's hearing. Thank you all for taking the time to participate in this hearing today. We appreciate your interest in protection of Michigan's waters. As a reminder, the public comment period will close at midnight on November 27th, 2024. The department will consider all comments received. If you still would like to make a comment but did not wish to make a verbal comment tonight, you're welcome to submit a written comment to Eagle through that time. Persons wishing to submit comments on the draft permit should do so through My Enviro portal or Alyssa Yanashko. Public hearing is now closed. Thank you again. Is there any closing comments from any of our panel tonight or anything that we wanted to say? I have 3 cards left, just so you're aware. The public comment period is open until November 7th, and I'll leave this slide up here for you in case you need to make those comments. Thank you much.
Ready for me to close? Can I close, Ryan? Ryan, are you good for me to close? Gary, are you good for me to close? And
Yeah.